Howdy, and welcome to another episode of Cooper's Code Lifecycle of a Case series, where we provide tools and tactics for the different phases of a case. We're compiling all of these episodes into a playlist on our YouTube channel, so head on over there if you want to see them all. For this section of the lifecycle of a case, we're going to be talking about two post-trial elements. One is post-verdict, and the other is appeal. So the post-verdict section is relatively straightforward in terms of where it falls in the timeline of a case. After a trial has been reached and a judgment has been entered, there is an opportunity to, in essence, attack or try to undo what the judgment was. One of the first steps in this process, and one of the earliest opportunities that one has, is shortly after the verdict has been read by the jury. Usually the judge will allow counsel to step out, or even sometimes in the courtroom, and talk with the jurors about the experience of trying the case. And this is an opportunity, if you like the verdict, to have conversations with the jurors who are both favorable to your result or who are against your result, to try and gather information about how that result was reached. A common tactic, if you don't like the outcome, is to talk to the people who were in your camp, vote against what the majority was in terms of the outcome, and try and see if something was done that was not okay. Did they consider information? Did someone bring in outside research? Was there something that someone didn't disclose in jury selection? Sometimes you'll find that what's going on in the jury room is something that was not okay. Now, that said, there is a judicial and case law bias towards not attacking the juror's deliberative process. So just know that while you may see juror declarations in to support a motion for new trial, either from the defense or from the plaintiff's side, that you have to overcome some legal rules related to those. So if you like the outcome, then one of the things that can be very helpful is talking to the jurors who are favorable to your side, letting them know that they may get outreach from the other side. Look, you did a great job. The defense may be sending around investigators or attorneys to interview you, and recognize that when they're doing that, their goal is to undo the work that you just did. The weeks that you just sat through trial, their goal is to try and get that judgment reversed. And so if they ask you questions, know that the direction of those questions is to try and see if there's a way to undo things. And if they ask you to sign a declaration, it's definitely going to be in support of a motion for new trial, something to undo what just happened. So those are ways to help shore up the results. Oftentimes the jurors will leave without wanting to stick around. Sometimes it's an exhausting process. And then one can take the time to track down jurors and politely reach out to them. Phone calls oftentimes are the best ways to do that. The foreperson is typically a clutch person to speak with. Jurors who are against you, again, are very useful, even if you won, to help hear what might come up in terms of a defense attack on the verdict. We oftentimes will try to reach out to all 12 jurors and conduct post-verdict interviews. And that also is not just for the outcome of the case, it's to understand, in essence, how to improve as a lawyer and how to improve thematically on a case. So in a lot of cases, lawyers will do focus groups. What one has done with a jury trial is the most expensive and longest focus group one can do, and getting the benefit of hearing how one succeeded in providing certain evidence, how one failed. And we always want to ask jurors about what could we do to improve in terms of how we communicated information. I'll share that one of the thematic takeaways that we've heard from jurors over the years is early in the technologic process, there was a concern that people used technology might be perceived as too slick. And what we learned in talking to jurors when the defense did zero technology or limited technology, and we had a lot of technology, was not that it was a slickness, but that it was really helpful that you provided the ones with technology, provided ways for us to easily understand the information. So that's the kind of learning that can be beneficial as one gathers information from jurors. In the post-verdict world, the things that you're typically going to see is there'll be a notice of entry of judgment that comes after the verdict. So the verdict gets turned into a judgment, and then there's the notice of entry of judgment. That's what starts the time clock. And once that notice of entry of judgment is entered, then the deadlines for motion for new trial, motion for judgment notwithstanding the verdict, memorandums of costs, motions to tax costs, and the notice of appeal. All those clock off of the notice of entry of judgment. The motions for new trial and motion for judgment notwithstanding the verdict are two motions that can be made to try to undo the verdict itself. Those are made almost always by the side who does not like the outcome. They fortunately are not, I won't say rare, but it's less common that those are granted. And typically there needs to have been something wrong done in the trial. And so that's an area where if you feel something was wrong, you want to make sure that you point that out. If you want to preserve things for appeal and you want to have good appellate arguments, it's always wise to make sure that you have done everything you can to bring things forward in the trial courts and give the trial judge the opportunity to correct those things before you take them up on appeal. This also is a good time to engage with appellate counsel, particularly if you don't like the outcome. That said, the best time to have access to appellate counsel is early in the case if you have somebody who you work with, just making sure in your motions in limine or any key evidentiary issues that you are going down the right path. What do I mean by this? Sometimes you might have a wobbler evidentiary issue. So you push to get evidence put into the trial to prevail, only to find out that wobbler evidentiary issue is one that then becomes grounds for appeal, or even worse, your case and your firm get associated with a result at the appellate court level that sends your case back for new trial, and then everyone out in the plaintiff's bar knows that you've now set this rule that you don't want to have associated with your outcome. So working with appellate counsel early in the process if you have any odd evidentiary issues can be very useful. It's also the right time to start talking to appellate counsel, even if you plan on doing your own appeal in-house. Say the case doesn't justify hiring on appellate counsel. It's going to be a stretch on the cost side. It can be wise to pay by the hour just to consult with someone so that you dot I's and cross T's on the appellate side. Beyond the motion for new trial and motion for judgment notwithstanding the verdict, there's the memorandum of costs. So if you are the prevailing party, you're going to prepare the memorandum of costs. You're going to want to include all of the things that you're entitled to there. This is where having good record keeping is clutch, because you don't want to be in a situation where you're digging through boxes of receipts or going through emails to try and find bills or other things. So having a great bookkeeping system is a very good way to make sure that memorandum of costs is easy to pull together. The standard prevailing party costs, and recognize that I'm going off the cuff. I'm not reading through a statute when I'm saying this, so make sure that you look at the statute when you're doing this yourself. But there's a difference between beating a formal offer to compromise under Code of Civil Procedure 998, also known as 998 costs, and prevailing party costs. Prevailing party costs are kind of the standard things. So jury fees, court reporter fees, filing fees, motion fees, deposition costs. Now, those can add up. Those have value. But really the great thing to have in your arsenal is a formal offer to compromise, a 998 number that you've beaten in the case. So let's say at some point in the case, you sent out that formal offer to compromise, that 998 for $100,000, and your verdict is $125,000, and you had $20,000 in expert costs because you had to bring your expert to testify and take depositions. Those costs that you expend on an expert, on exhibits, on other things that you get as a prevailing party under CCP 998, you get those as long as you made those expenditures before the 998 was issued. So this goes back to strategic timing on 998s. We always want to try and get a 998 out before we're doing big expert expenditures. So in a perfect world, before the experts are doing a lot of work, definitely before you have the experts preparing for deposition and being deposed, that then insulates you on those expert costs should you have to try the case. So you gather all that information into a memorandum of costs. You have all the supporting documentation. Guaranteed, you're going to get what is known as a motion tax costs from the other side. So, and the flip side is true. If the defense gets to put forward a memorandum of costs, you're going to want to most likely do a motion tax costs to try and go through and parse and make sure that things that should not be included are not being included in that motion. The other piece, and we talked about 998s before, but you get that 10% interest. And so when you're prevailing on a formal offer to compromise, you want to make sure that you include that 10% interest from the date of service of the 998. Some people include that as a memorandum of costs. Some others do a motion for costs under Section 998 in addition to the memorandum of costs. I've seen both. Whatever the court is willing to accept and whatever works is the way to go with that. So that's, in essence, the post-verdict dance. One then gets to what are known as appeals. So there are a variety of ways to handle appeals. Typically, even if one outsources the appellate work to a appellate specialist, there's still going to be work that needs to be done by the trial team in the case. The trial team is going to know the facts and know what happened in the case far better than anyone else. So that said, we usually retain an appellate lawyer. We may work on the statement of facts or other pieces ourselves in order to contain some of the appellate costs, because appellate lawyers usually are doing work on an hourly basis. So just consider that as you're building your team. The appellate lawyers, sometimes some appellate lawyers will be willing to do a contingent fee if you have cost issues or if your client has cost concerns, and that's an option, then you can consider striking a deal with an appellate lawyer as far as that's concerned. Obviously, the appellate lawyer is going to want to know the facts of the case, the law of the case, and the more likely one is to prevail on the appeal, the more likely the appellate lawyer is willing to do some form of contingent fee on that. That 10% interest that you get from a 998, you also get while a case is up on appeal. So one of the things to think about is, while one might be frustrated that you get a good verdict and the defense appeals that, there's no other place right now that I know of where you're going to be getting guaranteed 10% interest on. So that 10% interest can be a gift to the firm and to the client while that case goes through the appellate process, presuming one is going to prevail. There have been appellate mediations in a lot of the districts. That's been a way that the districts will try to clean up their docket and reduce the number of cases there. That process is typically happens with your case getting flagged. So while one can always engage in informal negotiations with the other side in terms of would you like to go to a mediation while it's up on appeal, sometimes your case will just be flagged and there will be an appellate mediation process. It's typically through not your usual mediators, but through a panel that the appellate district has available. Those can be productive. They also are ways to kind of hear from some of the people who are more involved with that district as to the strengths and weaknesses within a case. Appeals tend to be different than our usual cases in terms of extensions. And what do I mean by that? When your brief is due, oftentimes you can request an extension. The extensions tend to be more liberally granted. Now, that varies district by district and presiding justice by presiding justice in terms of the panel within the districts. Side note, and I didn't cover this, within each appellate district, there will be different panels. So the appeals process is heard by a 3-justice panel. Again, I'm talking California appellate process, not the federal appellate process. But in the California appellate process, there are panels within the district. So if you're in the appellate district 1, there may be 5, 6, 7 panels, and an appellate lawyer would have those numbers right at the tip of their tongue. The different panels oftentimes will get different reputations in terms of how many extensions they grant, whether they lean more conservative, more liberal, and whether they do things like issue tentative opinions or letters, because some of them do that now. And for those who don't spend a lot of time in appellate court, this was something that was a relatively new learning for me. I went to an appellate seminar probably 4 or 5 months ago. It was really interesting to hear that the appellate courts have started to recognize the benefit of doing tentative opinions or letters. And so what are these? In the week or so before oral argument, they will sometimes issue a tentative opinion. This is the direction that we are planning on going, so that when you show up at the hearing, these are the issues that would be beneficial for you to address, if you like them, with your argument to strengthen these positions, or if you don't like them, what cases or facts undercut the tentative opinion. The same is true with letters. Sometimes some of the panels will issue a letter stating, "We'd love to know more information about this issue." And that sometimes can be an invitation for the briefing or just an advisement that these are the types of things that they want to hear at the oral argument. Oral argument in appellate court these are the words of somebody who does not do a lot of appellate work. I would describe it as much like one's law school moot court experience or the most prepared law in motion hearing one has ever done. So going in there, being ready to address the court's questions, honor their questions, and make sure that even if one disagrees with the direction of the question, that one has a good response. And in essence, being deeply seasoned, deeply rooted in the case. Once an opinion is issued in the appellate court, that opinion then can be subjected to a petition for review by the California Supreme Court. That is not granted in every single case. In fact, it's fairly rare that it's granted, but sometimes it happens. While that petition is being submitted, there's a delay in terms of that appellate ruling being final. Presuming the Supreme Court does not pick it up, then the opinion becomes final. If the judgment is, the trial court's judgment is upheld, then it's off to the races in terms of, presuming that there was a judgment in your favor, it's off to the races in terms of the collection of that judgment. Sometimes it's reversed or partially reversed for some issues. Then it goes back for new trial, and one gets the joy of trying a case a second time. Side note on trying cases a second time, that can sometimes be beneficial because one has a lot more information about what resonated and what didn't resonate. It also gives the other side an insight into how you tried the case. And so just know that second trial can be a daunting experience in terms of having to do that again. And with that, I believe we've covered the post-verdict and appeals process. Thank you for tuning in. If you enjoyed this, check out our previous episodes. More will be coming soon. If you're enjoying what we're doing here with Cooper's Code, please help us extend our reach by giving us a 5-star review on Apple Podcasts, and consider sharing an episode with a friend. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions you have for who you'd like to see on the show. To all of you doing justice out there, happy hunting.